LiSTNR production.
A warning. This podcast contains descriptions of events and situations that some listeners may find disturbing or distressing. Please listen with care. This week's episode came as a suggestion from one of our listeners via TikTok. Sophie said, "Hey, I love your podcast. Would love to hear the case findings of the murders of Karlie and Khandalyce Pearce, who were both murdered in New South Wales. Have a lovely night." Thanks, Sophie. We love hearing from our listeners, and if you have a suggestion for a case you'd like us to look into, reach out via social media, and we'll do our best to follow it up for you. This is a horrific story. Karlie Pearce-Stevenson and her daughter, Khandalyce Pearce, were tragically murdered in 2008 in a case that shocked Australia. Their deaths remained unsolved for several years, with their identities and the circumstances of their deaths only being uncovered in 2015. I'm Dan Mullins. This is Crime Insider's Judgement, a deep dive on a judge's final verdict of a crime and what transpired to incite that judgment. Karlie Pearce-Stevenson was a 20-year-old woman from Alice Springs in the Northern Territory. She was a mother to a daughter, Khandalyce Pearce, born in 2006. The two shared a close bond, although Karlie's life was marked by difficulties, including struggles with relationships and circumstances that pushed her into transient living. In late 2008, Karlie and Khandalyce left Alice Springs. They were known to be travelling around, seeking work and new opportunities. Their last confirmed sighting was in November 2008 in parts of New South Wales. After that, they effectively vanished. Karlie's family became worried and filed a missing persons report in September 2009. However, that report was withdrawn shortly afterward because Karlie had made contact with family members by phone and text, suggesting she was alive and choosing not to reconnect directly. This complicated the efforts to find them, as authorities assumed the pair was safe, but intentionally out of contact. Unbeknownst to their family and friends, both Karlie and Khandalyce were in grave danger. Their disappearance was not a voluntary choice to isolate, but rather the start of a dark chapter that would only come to light years later. In 2010, 2 years after Karlie and Khandalyce disappeared, a grim discovery was made. In the Belanglo State Forest in New South Wales, a place notorious for the site of the Ivan Milat backpacker murders, some dirt bike riders stumbled upon skeletal remains. The body became known as the Angel of Belanglo because of the clothes she was wearing, a t-shirt with the word angelic written on it. Police believe the remains had been there for around 12 years, which ruled out Milat as he'd been incarcerated since the mid-1990s. There was no immediate connection to the missing persons report, as Karlie's family had believed she might still be alive. There were few leads, and the case became one of the many unsolved homicides haunting Australian law enforcement. Then, in July 2015, another shocking discovery occurred, this time in South Australia. The body of a young child was found inside a suitcase near the Karoonda Highway. The child's identity was initially unknown, and the brutal circumstances of the death sent shockwaves through the community. Police released images of the dress the child was wearing when she died. In the Northern Territory, Tanya Webber recognised the pink dress. She'd seen her best friend's granddaughter wearing the same dress in Alice Springs 7 years earlier. Tanya called Crime Stoppers, and detectives had the information they'd been looking for. DNA testing would later confirm that the child was Khandalyce Pearce, Karlie's daughter. But no one knew where her mother was. South Australian police worked with New South Wales police to piece together the identity of the child's mother. Detectives went all the way back to Khandalyce's neonatal heel prick results and compared them with the remains found in the Belanglo forest, and they had their match. The revelation that mother and daughter had both been murdered was devastating. It connected the dots of the two disappearances and turned the case into a national tragedy. Police reopened their investigation with renewed urgency. It became clear that someone close to the victims was responsible. This is a truly harrowing story. Police later arrested Daniel James Holdom, who later pleaded guilty to the two murders. I'll read directly from the sentencing judgment delivered by Justice Robert Hulme in the Supreme Court of New South Wales on October 30, 2018. The judgment provides the background and details of what led to the deaths of a young mother and her 2-year-old daughter. Justice Hulme refers to Daniel James Holdom as the offender. In 2008, the offender was 34 years of age, and he had been in a relationship with Miss Hazel Passmore for about 2 years. They met in Queensland and then moved to New South Wales and Victoria before settling in Alice Springs. Ms. Passmore, at that time, had 3 children from a previous relationship. The offender has consistently, but incorrectly, claimed that he is the biological father of Miss Passmore's 3rd child, who was born in December 2005. Ms. Passmore told police that over the course of her relationship with the offender, he showed an interest in child abuse material and at times asked her to recount her own sexual abuse as a child to get himself aroused. He also asked her to write stories about child abuse. While they were in Alice Springs, the offender and Ms. Passmore met and became friendly with Karlie and Khandalyce. Khandalyce was about the same age as Ms. Passmore's youngest child. On the 15th of September 2008, on the Sturt Highway in northern South Australia, the offender and Ms. Passmore were involved in a car accident in which the offender was the driver. Ms. Passmore's 2 eldest children died instantly. Ms. Passmore sustained serious injuries, including losing a leg through amputation, and she spent a lengthy period in hospital and then in rehabilitation. The funeral for the 2 children was deferred until she was sufficiently recovered to be able to attend. Ms. Passmore said that while she was hospitalised in Adelaide, the offender came to visit and he was accompanied by Karlie and Khandalyce. Ms. Passmore said that the offender and Karlie had become really chummy. She realised she could not do anything about it and told the offender in emphatic terms to leave her. On the day after the funeral of the 2 children, on November 14, 2008, the offender travelled with Karlie and Khandalyce to the Australian Capital Territory. There, they stayed in the suburb of Charnwood at the home of the offender's cousin. At around this time, Ms. Passmore messaged the offender, telling him that she was going to sue him over the car accident due to bills and expenses relating to her rehabilitation. At about 2:30 a.m. on December 15, 2008, the offender and Karlie left Charnwood in her car. Prior to this, they had been arguing, but what that was about is unknown. They left Khandalyce behind in the care of the offender's cousin. They arrived in the vicinity of Sutton Forest and the Belanglo State Forest not long before 5 a.m. The offender murdered Karlie in the Belanglo State Forest late in the morning of December 15, 2008. He sexually assaulted her at around the time of her death. He took a number of photographs of her, which he retained. The details of what Karlie endured will not be outlined in this podcast out of respect for her as a victim. Back to the judgment. There could have been no dispute that these were photographs taken and kept by the offender. They were found on an SD memory card, which also included many deleted photographs of the offender and people known to him. They included a roadside photograph of the skull fragment of one of Ms. Passmore's deceased children from the accident on the 15th of September 2008. Police investigations determined that the photographs, including those taken in the Belanglo State Forest, appeared to have been taken by a camera, which I take to mean not with a smartphone. The offender left the area just after midday and drove in Karlie's car back to Canberra. He told his cousin that he had had a fight with Karlie and had dropped her off at the bus stop. His cousin, using a nickname for the child, asked, how could she leave candles? The offender replied that Karlie sometimes did that and said, I'm taking her to her grandmother's in South Australia. The offender traded in Karlie's car at a car dealership in Canberra on the 17th of December and obtained another car, an old Holdom Statesman. He continued staying with Khandalyce at the home of his cousin until 2 days later, when he packed up his and Khandalyce's possessions and left. Khandalyce was never seen alive again by anyone who knew her. The offender drove with Khandalyce from Canberra towards South Australia. He stopped at a supermarket in Wagga Wagga and purchased a number of items including body wash gel, multi-purpose wipes, garbage bags, and duct tape. At around 11 a.m, the offender checked into a motel in Narrandera. Mobile phone tower data shows that he was in Narrandera for about 2.5 hours. It was probably here that he killed Khandalyce. The means of causing her death was suffocation. The statement of facts includes the following. There was a sexual motive involved in the murder, and the offender was at least attempting to or planning to sexually assault Khandalyce at the time of her death. Khandalyce was only 2.5 years old. The offender arrived at the home of a member of Ms. Passmore's family in South Australia in the early hours of the 20th of December. He was alone. Ms. Passmore told police in 2015 that she resumed the relationship with the offender after his return to Adelaide at Christmas 2008. He gave her conflicting accounts of where Karlie and Khandalyce were. She thought they must have remained with the offender's relatives in Canberra. The offender and Ms. Passmore stayed together until sometime in 2010 when the relationship ended after an argument over the offender using drugs. On the 4th of September 2009, Karlie's mother, Ms. Colleen Povey, went to a police station in the Northern Territory and reported that she had concerns for her daughter and her granddaughter. She had not seen them for almost a year since they left the Territory. Ms. Povey said that Karlie had not kept in contact. Call charge records showed that the last occasion Karlie contacted her mother was on the 13th of December 2008. Subsequently, calls and texts to Karlie's number were unanswered. Ms. Povey filed a missing persons report. On the 7th of September 2009, Northern Territory Police spoke to the offender by telephone. He said he understood that Karlie had moved to Queensland and he had not heard from her since February 2009. He told police that he may have a further contact number for her and asked to be called back that afternoon when he would provide it. Further attempts to make contact with him were unsuccessful. Police made contact with a credit union with which Karlie held an account. They were told that her account was being used regularly and had recently, just days before, been accessed at an ATM in South Australia. Police took this to be a sign of life. Ms. Povey was informed of this, but she was told that police would keep the missing person report open until Karlie was sighted or spoken to. On the 10th of September, Ms. Povey contacted police and told them that she had received a text message from Karlie saying that she was okay. She said that Karlie did not want to provide any details about her location. It is an undisputed fact that this contact was made, cruelly, I add, by the offender or by someone at his instigation. This feigned contact from Karlie caused the missing person report to be closed. Miss Karlie Povey, Karlie's mother, passed away from breast cancer in February 2012. In a family impact statement, it was said Ms. Povey's last utterance was to ask, "Are Karlie and Candles here yet?" This was not the only cruel aspect of this deception by the offender. Coming up, the admissions Holdom made in relation to the murders. Justice Hulme then addresses the precedents I outlined earlier about Karlie's remains being found in the Belanglo forest and Khandalyce's remains being found beside a highway in South Australia, and the linking of the two through DNA. I'll return to the sentencing judgment at the part where the judge addresses admissions Holdom made to his former partner, Hazel Passmore. It has been mentioned that the offender gave conflicting accounts to Ms. Passmore about what had happened to Karlie. He told her she had returned to Alice Springs, but had also claimed she had gone to Queensland. In mid-2009, Ms. Passmore was looking through the boot of the car that the offender had driven back from Canberra, and she found items belonging to Karlie. This made her angry because she suspected that the offender had lied and that he was still in some type of relationship with Karlie. When she confronted him, he told her that Karlie was dead. He told her that he had raped and killed her. She asked him about Khandalyce, and he told her that he had suffocated her. Ms. Passmore asked the offender why he had killed Karlie, and he said that it was because he wanted to come back to Ms. Passmore. According to her, he said, "He did it for me." The judge then moves on to the issue of Holdom pretending to be Karlie after he had murdered her. The offender engaged in a number of activities following the murders that gave the impression that Karlie and Khandalyce were alive. He used her mobile phone to send text messages, including to members of her family, such as her mother, purporting to be from her. Such messages were sent as early as a few days after the murder, and there was a flurry of them soon after the police made contact with the offender in September 2009. Police subsequently determined that the offender used Karlie's mobile telephone service up until May 2011. The offender also used Karlie's bank account after her death. Funds were transferred to the account by Centrelink and the Australian Tax Office. The offender's employer credited his wages to the account. Aside from withdrawals and transfers from the account, he charged expenses to Karlie's credit card. Ms. Passmore also charged expenses to the account. This activity continued through 2009 and up until 2012. The offender also engaged in fraudulent activities relating to Karlie's social security accounts, including Centrelink, Medicare, and child support. By way of example, in mid-December 2010, an associate of the offender, purporting to be Karlie, attended a Centrelink service centre and produced a copy of Khandalyce's birth certificate. This interaction resulted in more than $7,800 for arrears of family tax benefit and rent assistance being credited to Karlie's bank account. The total amount fraudulently debited from Karlie's bank account after her death is in the order of $72,000. A number of Karlie's belongings were found amongst the offender's possessions when police executed search warrants in 2015. These included her mobile phone, Medicare card, and a library card. The offender was interviewed by police on the 21st of October 2015. He denied involvement in or knowledge of either murder and told some elaborate lies in support of such denials. He was interviewed again a week later when he told police that most of what he had said in the first interview was not true. He then told different lies. Following the second interview, the offender was arrested and charged with the murder of Karlie. He told police, "You've got the wrong guy. You'll see." In mid-December that year, the offender was arrested and charged with the murder of Khandalyce. The judgment then addresses the offender's accounts of the murders as provided to forensic psychiatrist Dr. Olav Nielsen and evaluates the reliability of this account alongside the offender's background and its potential influence on his crimes. Holdom told Dr. Nielsen that he killed Karlie during a trip after an argument where she threatened to reveal an affair to his ex-partner, Hazel. He claimed he struck her with a broom handle and left her alive but dying, panicking due to his intoxication with MDMA and methamphetamine. Regarding Khandalyce, he stated she was suffocated in Canberra to avoid questions about her mother's absence, and her body was later abandoned. The court found these accounts substantially inaccurate. Karlie's injuries were inconsistent with a broom handle assault, suggesting severe actions like stomping, and photographic evidence contradicted his claim of leaving her alive. Khandalyce's murder location was also disputed, undermining his narrative. The court noted deficiencies in explaining his motives, particularly his failure to address incriminating photographs. Holdom's background was examined through Dr. Nielsen's report, a 2014 report by clinical psychologist Miriam Weisenbeek, his sister's statements, and historical records from the 1980s. These revealed a dysfunctional, abusive upbringing marked by physical, emotional, and sexual abuse from his stepfather, neglect by his mother, and periods in foster care from age 8 or 9. Despite inconsistencies in his accounts, such as varying reports of his father's death and relationship durations, the court accepted that his early trauma caused significant maladjustment, contributing to mental health issues, substance abuse, and criminal behavior. However, discrepancies between his self-reported history and historical records, coupled with his history of dishonesty, offences, and fraudulent actions post-murder, like using Karlie's identity, raised doubts about his credibility. Dr. Nielsen gave his opinion that the offender's abusive childhood likely contributed to the murders, citing psychological processes like heightened threat perception and reduced emotional regulation. However, the court approached this cautiously, noting Dr. Nielsen's reliance on the offender's untested, inaccurate account and his misinterpretation of the offender's post-abuse life, which included periods of stability. Historical records showed improved behavior in foster care, contradicting claims of persistent turbulence. The offender's criminal history, starting at age 19, included assault, fraud, and a 2013 child sexual assault, but lacked evidence of adolescent antisocial conduct that Dr. Nielsen suggested. Consequently, the court found Dr. Nielsen's causal link between the childhood abuse and the murders unreliable due to these inconsistencies and the offender's lack of truthful explanation. While the upbringing was considered for sentencing, its direct causal connection to the crimes was not conclusively established, emphasizing the need for caution with unverified statements in sentencing proceedings. I'll now return to reading Judge Hume's judgment, where he addresses remorse. Remorse may be taken into account as a mitigating factor on sentence if the offender provides evidence that he or she accepts responsibility for what was done and acknowledges the injury, loss, or damage caused. It is necessary to refer to that because at the beginning of his submissions, senior counsel for the offender announced that his client apologized for his offenses to the relatives of the victims and the court. That clearly does not satisfy the statutory requirement for remorse, and it was later clarified that it was not intended to. Dr. Nielsen's report contains the only attempt made by the offender to explain what he did and why he did it. This was a report specifically prepared for the purpose of sentencing, but even there is no suggestion that the offender said anything to indicate he was remorseful. Statements were read at the sentencing hearing on behalf of Mr. Bruce Pearce, Karlie's father, and Khandalyce's grandfather, Ms. Lorna Pearce, Karlie's grandmother and Khandalyce's great-grandmother, and Mr. Scott Povey, husband of Ms. Colleen Povey, the late mother of Karlie and grandmother of Khandalyce. There are many aspects of the grief they and all of the family and loved ones of Karlie and Khandalyce have suffered. They were cruelly given to think they were alive, which gave rise to the torment and despair of not knowing where Karlie and Khandalyce were or what they were doing, and to some extent, anger as to why they had not returned home, or at least why Karlie was not making contact. Sadly, Karlie's grandmother Connie passed away in September 2011, and her mother Colleen passed away in February 2012, and still there was no contact. The dreadful news that came in October 2015 compounded the pain and anguish for the rest of the family. Recognition of harm caused to the community is one of the purposes of sentencing. In this case, the impact of the death of Karlie and Khandalyce upon their immediate family is substantial, but otherwise unquantifiable. It will be taken into account in determining the punishment to be imposed upon the offender. I respectfully extend my most sincere sympathy. In making findings about matters that are adverse to the offender, it is necessary that I be satisfied of them to the standard of beyond reasonable doubt. The lesser standard of the balance of probabilities applies to findings that operate favorably to the offender. In relation to the murder of Karlie Pearce-Stevenson, I accept completely the Crown's submission that the last moments of Karlie's life must have been horrendous. She was physically separated from her child, alone in an isolated location in a forest with a man she had trusted and had romantic feelings for. He was a man of considerable height, size, and weight, whereas Karlie was described as being of childlike stature. Even without being able to be satisfied beyond reasonable doubt what it was that motivated the offender to do what he did, I am satisfied that the manner in which the offender killed Karlie Pearce-Stevenson and the circumstances in which it occurred amount to a murder of extreme gravity and appalling depravity. It is a murder at the top of the range of objective seriousness. In relation to the murder of Khandalyce Pearce, this murder is also at the top of the range of objective seriousness. That is, so even if only on the bare fact that the victim was a completely defenseless 2-year-old who was intentionally killed with some forethought by being suffocated and stuffed in a suitcase and dumped. Adding to this, the sexual assault element only makes it the more despicable. The various ways in which a mental disorder or disability at the time of offending or at the time of sentencing may be taken into account, have been described in many well-known appellate cases. For the purposes already given, I am satisfied that the offender's actions were deliberate, purposeful, and subject of some prior consideration. I am satisfied that the offender completely understood what he was doing and its wrongfulness. I am not satisfied that the offender had a mental health condition that contributed to the commission of the murders in a material way. His moral culpability is not reduced on such account. There is nothing to justify less weight being given to either general or personal deterrence, nor anything that means that a custodial sentence may weigh more heavily upon the offender. Murder is an offence that carries a maximum penalty of imprisonment for the term of a person's natural life under Section 19A of the Crimes Act. There is force in the Crown's submission that the offender's conduct in murdering Karlie and Khandalyce provides a picture of a man devoid of real empathy and care for other people, and motivated largely, if not solely, by self-interest and self-gratification. In considering Holdom's childhood abuse in relation to mitigating circumstances, the judge said, "It is possible that the circumstances of the offender's upbringing did play a role in shaping the course of his future life. It may have rendered him more susceptible to depression and to engage in the use of illicit drugs, if not all the time, then at least at times of personal stress. There may have been in some way an imbalance in the offender's moral compass as a result of the harsh physical abuse and indignity of the sexual abuse he experienced at the hands of his stepfather, which was not counterbalanced by having the love and support of his mother. That is about as much weight as may be given to this subject. In the end, however, I am satisfied beyond reasonable doubt that the offender has a level of culpability for each of the two murders that is so extreme that the community interest in its protection and in retribution, punishment and deterrence can only be met through the imposition of a life sentence. That does not necessarily mean that life sentences must be imposed, but aside from consideration of the statutory provision. I am also satisfied that each of the offences meet the common law description of being in the worst case category. They are crimes that meet the description of being of very great heinousness. Having regard to either basis, I am satisfied beyond reasonable doubt that the offender's culpability is so extreme and that his crimes are of a level of heinousness that no objective or subjective factor or factors mitigates the need to impose the ultimate sentence. The offender is convicted for the murder of Karlie Jade Pearce-Stevenson at Belanglo State Forest on the 15th of December 2008 and the murder of Khandalyce Pearce at Narandra on the 19th of December 2008. For the murder of Karlie Jade Pearce-Stevenson, the offender is sentenced to imprisonment for life. For the murder of Khandalyce Pearce, the offender is sentenced to imprisonment for life. Both sentences are to date from September 15, 2016. Daniel James Holdom will never be released. Thanks for listening to Crime Insider's Judgements. We love hearing your feedback, so please rate and review this episode. If you have a case you want us to cover, let us know via Instagram at LiSTNR Crime or TikTok at LiSTNR Crime Team. I'll be back again next Thursday with another case. I'm Dan Mullins, with sound designed by Niall Fernandez. This series was recorded and produced on Gadigal land.